We're very lucky that we have some great participants here, and I hope that you all will enjoy our show. Keep in mind that today's presentation is being done for educational purposes. There are lots of things that are being stated that should not be attributed to anyone that is stating them or not stating them. To the abstract principle.
Mr. Macedo, didn't this court previously rule that merely because there was a transformation, while it provided a useful clue as to patent eligibility, did not make a claim patentable, and that if it was so broad as, or so abstract as to preempt the law of nature, that it could still be held patent ineligible? And here, your claim 9, as you define it, is merely a signal that's used to be transformed into mechanical movement for printing or marking. And that's so broad that it would cover things such as the teletype or fax machines, inventions that came long after this. And so isn't it so broad and abstract as to be essentially equivalent to Claim 8 that we already held invalid?
Well, a couple points, Your Honor. First of all, the breadth of a claim does not make it abstract or not abstract. As the Supreme Court recognized in its recent decisions, you can have an abstract principle that is preempted by a very narrow claim, and you can have a very broad claim which may not preempt the abstract idea. So it is not the breadth of the claim that determines patent eligibility, I respectfully submit, because if you want to talk about over breadth of a claim, you should look to Section 112 with all due respect. What matters is, in terms of a preemption analysis, is there any way that the fundamental principle involved in the claim can be practiced outside of the scope of the claim? In the example I just gave, the fundamental principle, if you were to define it as transmitting letters, numbers, or symbols over a distance, even using electromagnetic energy if you want, could still be practiced by using a light bulb instead of mechanical movement. Thus, it is a particular application of that fundamental principle rather than the fundamental principle
Our holding
itself.
in Invention, with all due respect to the Federal Circuit's view, which I know we often do not defer to. In Benson, didn't we say that the Section 101 issue is based on a determination that the claim preempts all practical uses of the algorithm, even though it recites some hardware? So, for example, in Benson or CyberSource, those cases are more about preemption, about a scientific principle, than about whether or not determining a claim that has hardware in it is abstract. So I guess the question is, are you suggesting a claim which does meet the machine or transformation test can still be found invalid as non-patent eligible under Section 101?
Yes, Your Honor. The Supreme Court in Mayo just did exactly that, and the claim was found to meet the transformation test, but the claim was still found to be invalid because it preempted a law of nature and involved mental steps and so forth. So the answer to your question is definitely yes. You don't have to, no determination needs to be made that you're preempting all practical uses of an algorithm or a method of accomplishing something. You have to just try and dissect out whether or not the invention is directed towards an abstract idea, scientific principle, mathematical formula, rather than try to imagine whether every possible use, all practical uses of the invention are usurped or preempted by the claim.